This should never happen to anybody. I mean, I've always believed that. It's not about me. This isn't about me. It's not about how I've been necessarily treated. It's not about money I don't have any longer. It's about families that are going to this courtroom should never have to go through this. It needs to be done in a timely and a just and fair way, and that is not what's happening. And that isn't right. It shouldn't continue. And I think that this is the norm. I mean, that when you talk to any attorney, they laugh and they say, I mean, honestly, they do. They go, well, this is how it works. I mean, it's not about that. Oh, I don't get that. I don't know why you need a law degree then. I think at this point, as of today, that the advice that I would have to give is you need to have the most powerful, ruthless lawyer on your side that is a member of the Geauga Bar Association, or you don't have a chance in this court. And that may not work. I mean, I suppose it will. As long as he's part of this good old boy network, then you probably have some sort of fighting chance. Unless there's other circumstances surrounding favoritism that I wouldn't know about, and none of that should be going on in any court, but it does. I think that's the word on the street is, well, this is just how the system works. Well, it shouldn't work that way. It shouldn't work that way anywhere. I don't understand that, and perhaps it'll change. Judge Burt let my case, because we objected, he let my file sit on his desk as well. But he doesn't have a time limit. That's what I learned. The magistrate has a time limit. He broke that. We had to sue him. Burt doesn't necessarily have a time limit. He just let my file sit on his desk. After approximately 8 months, we did it again. We sued him through I think it's through the Court of Appeals. I think it is. I think Cliff told me that yesterday. So we did that to him. It took him another 2 months for the final decree. We sued him on March 23rd, 11, and he made his final court decree on May 5th of 11. So I started to, a long time ago, make sure that the agency was going to be firm through what I thought was going to happen, and it in fact happened. And so, was it a blessing that I did that? Absolutely. What the court thought is that because you own your own business in Geauga County or anywhere, that you can manipulate. Okay, they have this idea that any self-employed person is a criminal. I think that's what I think, because you can manipulate. And all throughout my trial, I said, well, show me how I manipulated it. Okay, just show me. I can't fathom, that I don't know how he can do that. I mean, as far as I'm concerned, I think he is changing Ohio law in that decision the magistrate did. We've objected to that. And it just, the decision that came down was just riddled with things of this nature that are just beyond belief. I mean, I can't explain it, and I'm trusting in the fact that the Court of Appeals can look at this stuff and read it and go, well, how did he do that? I know the money is gone. It's not about the money any longer because it's already gone. And the chances of any person ever getting that back is probably slim to none. The sad thing about it is that it was my child's education fund. Fine, it was college, but it's gone. And that just breaks my heart that I don't have it there after X number of years of setting this aside, with my broker. This is how much we should do, and put this amount in there, and we'll put it in safe funds. And so, it'll be, when she's 18, it'll be maybe $210,000. Well, sure, that won't pay for MIT, but it's all gone. And well, as I said yesterday, I mean, every day that rolls by in any kind of case like this, it's hard. I mean, it's like it kept me in a desperate situation all the time, trying to figure out how to financially handle the burden they put me under, and certainly emotionally, not so much for me. It eats me up. It breaks my heart. I think I was saying yesterday I don't want anyone to have to go through this. No one should have to go through this. And I've been through it. And they're going to have answers for it. They're going to say, like I said yesterday, oh, this was a complicated case. Well, it wasn't a complicated case at all. There was nothing complicated about my case in the least bit. What they did, what this court did, is make it complicated on purpose. And as every single decision in my case beginning in 2008 went against me, we knew from the beginning that we had to object to every single decision, because we knew that we would have to order the transcripts, because we knew that if we were going to go to the Court of Appeals from the third week or fourth week of this trial, because we tried to recuse the magistrate because of his relationship with my ex-wife's attorney over bike riding. And that came out. That upset the court. That upset Burt, because, again, the magistrate is his right-hand man. And Burt saw absolutely no problem with the attorney not disclosing the fact that he had this previous relationship. So we lost that battle, and I think the battlefield was set. Other than the fact that I had an out-of-county lawyer who has gone to bat for me every single minute of the day, every single minute of the day up until today through this whole trial. And it's been very hard for him. He has sleepless nights. The issue of trying to think about the kids in this situation, for the court to ignore the children of any family that goes through this, is just outright wrong. And I know for a fact that they didn't care about those feelings of any children. And again, that broke my heart. The case went down a road. My case went down a road of having expert witnesses on my part come in and testify, and tax returns, and it just went on and on and on and on. And I had to prove, which I think I did beyond a shadow of a doubt, that this is my income. These are all the people that testified, and the magistrate all throughout this case in his decision as well, which is certainly public record. And in all the testimony, he basically said, I don't believe anything that you said. I don't think that you're a credible witness. I don't believe your federal income taxes. I don't believe your CPA that you've had for 23 years. I don't believe your... And I don't understand that, and that's why there is an appeals process. It was totally ignored, and I was sort of made a fool of. I mean, I think that's the feeling that the feeling I got is that, well, we can do anything that we want, and this is obviously all made up, which it isn't. And I mean, that hurts me. That hurt me a little bit. I've been paying my federal income taxes since I had a paper route, and I this is what I do. I pay my bills. I pay my taxes, and this is the kind of feeling that I got out of this court from day one. And, well, in the first month or two of the trial, I hired a local attorney in Geauga County to help Cliff and I figure out why we were being treated the way we were in this courtroom, so we would have some local presence. And this attorney shared some information with us about Schmal here and my ex-wife's attorney as having a bike riding relationship in some, whether it be on weekends or in a club, and my attorney approached her attorney at some point and mentioned the fact that my attorney felt that this should have been disclosed, and my ex-wife's attorney said he denied that allegation, and then he recanted that allegation, and we went down this little rabbit trail, but for an hour or so apparently, because it was behind closed doors, and then it was determined that yes, in fact, he had this prior relationship riding bikes, and my understanding of the whole thing was that that perhaps my ex-wife's attorney had an obligation to disclose this to my attorney in the beginning, which he did not do. So our only recourse was to ask for the magistrate to be recused from the case, at which point it went to the judge. The judge, within, I think, a day, he made a decision that he felt that there was absolutely no problem with Magistrate Schmal here hearing my case. He just poo-pooed it, and that was that. So here we are, going forward, knowing that what we're going to have to do is probably, which in fact we had to do, is appeal every decision that went against me and every single issue that came up in this case that got dragged out. And why we felt that this was improper, this relationship between my ex-wife's attorney and the magistrate was clearly evident to us when it took 9 months for the magistrate to make a decision on my divorce decree, and when the law says you have 90 days to do that, and I had to sue him. And well, it became apparent to me. I mean, I'm a businessman, and I'm trying to figure out how am I going to get a fair shake in this courtroom. I needed to talk to a couple local attorneys that would take the time and agree to sit and listen to what's happened so far in my case. and give us some feedback as to why this was happening. And this local Geauga County attorney, who's right in Chardon, said, look, this is the way it works. Okay? I can't begin to explain it because it shouldn't work that way. He goes, you're from Geauga County. This is what's going to happen. And so either you don't have a choice about that, because I was gonna keep Cliff as my attorney, but maybe continue with this guy or not, but he made it quite clear that that's how this whole system works. It's a good old boy network. Okay, that's what I call it. And there aren't that many attorneys that belong to the Geauga bar, and you have someone that is in charge of his courtroom over a long period of time that maybe is over his head with he's running it like a king or something, and that's not the way a court should be run. I mean, you because of incorrect decisions, I think, that were made by the judge, in the fact that, well, he doesn't see a problem with a relationship of bike riding, and I don't think that that's a fine line, by the way. I think that's different than going to a cocktail party and having a lawyer talk to a magistrate. Certainly that's not a conflict of interest, but when you have two people that are riding bikes together and doing that type of thing, I think it warrants a real hard look at following the law, at least disclosing it, which her attorney never did. Yeah. We didn't object to Burt then, because the problem, I think, is that this was really overwhelming, and we had two options: to continue down this road, not knowing how long it would take. I mean, this began in the first year, and if I was in a position to have known all that, we could have had a chance. We could have objected to the Supreme Court, or we could have gone further. And I don't think that's called an objection. Whatever it is, we would have gone to the Supreme Court and tried to go that route to take care of this magistrate. And I mean, something as simple as the magistrate saying we didn't prove we were in a recession. Well, they wanted me to, at every turn in the case, spend thousands of dollars that I don't have. They knew I didn't have it, and they said it afterwards. Well, you didn't prove that you're in a recession. You just say that the insurance industry is affected. It's actually a ludicrous statement as far as I'm concerned. People were losing their jobs in '09. Thousands of houses a day were being foreclosed. We were in a national crisis. Ohio's in a crisis. I did certainly bring in evidence of that fact in paper form. But once again, the court says, well, we don't believe that we don't believe we're in a recession. So you're hiding money somewhere, and this just kept going on and on and on, and they put me in a position financially where I had to borrow money, and they just kept the pressure on me. I had to keep the house. Well, that was probably the most humiliating thing that I've ever done in my life. But it was what it was, and I had within 3 days I did surrender that, or 4 days or something, whatever the paperwork took. We tried to strike a deal before I went to jail to assign that policy to my ex-wife. But for whatever reasons, they declined. The judge actually thought a week earlier that that was a good solution. But when it came to the final hearing and our suggestion to transfer it to her, he went away and he made his decision. He said, "I'm not going to allow that transfer. Since you didn't surrender the policy, you're going to jail. You have to report on this day." My belief about this whole system is that they really don't care if they destroy people's lives. I don't understand that. But the real issue is that when courts take it upon themselves to try to destroy people's lives, which is the way I feel, that's what's happened to me. They can't destroy me, though. I mean, I have a spirit that cannot be broken, and everything that's happening here is happening for a reason. But courts should not be destroying people's lives and disrupting families like this, including the children, which is the most important issue. It's just, it's beyond, it's beyond right. I mean, it's so wrong that I feel that I need to speak up about it. It just shouldn't happen to anybody. I've always felt that they were punitive and retaliatory towards me because of that recusing. No, you can't do this in my courtroom. It's very apparent to my attorney and to myself. To me, it was punitive in their treatment of me. It certainly wasn't fair. It wasn't equitable, and so did the attorney I hired from Geauga County to help advise us on why these decisions were coming down in the very early goings of this trial. He felt that way. This lawyer that I hired from Geauga County felt that this relationship between Schmal here and her attorney was affecting the outcome of my case at that point. So my attorney called him on it. My attorney called her attorney on this issue and said, "We have found out that you have a prior relationship with the magistrate that wasn't disclosed," and it was denied, then recanted, and then the lawyer then admitted that yes, he did do a bike riding, and it was only maybe once or twice. Then he recanted that and said, well, it may have been more times than that, and it was just the lawyer talking, not the magistrate. And at that point, my lawyer decided that he had we certainly have the right to ask for the magistrate to be recused by filing a motion to Judge Burt, which he quickly, I think in a day or two, it might have even been the same day, he flatly said, "I don't see any problem with them riding bikes together." And I believe from that day forward, it just got worse for me. I believe they were retaliatory towards me and punitive towards me because we threatened them with this. And I thought it was my right. I still do. And it should be my right to bring that up. And I believe it should be a lawyer should go by the canons of law or whatever these, well, I should probably disclose, but that I ride bikes with this guy in the very early beginnings of this whole thing, but that never happened. And so it leads to this good old boy network that I believe is going on out in Geauga County, which I've referred to before, that seems that everybody knows this is what goes on, and it's who you know, and that's the way this case is going to go. I don't think it's really has anything to do with male or female. I think it has to do with whose lawyer is whose, and certainly having a Cuyahoga County lawyer representing me, not familiar with the territory, certainly didn't bode well in this so-called fair and just court for me. I don't think that's right. I should be able to hire F. Lee Bailey if I want to. Add this to the mix of uncertainty, being financially strapped by a court, in my case, every month facing contempt charges. Every month that this case was delayed because of the magistrate or the judge not making a decision on my divorce decree. Every single month I was in contempt of court. And that's exactly where they wanted me. I believe that. I believe they were retaliating. Even though I was in contempt of court every single month, it didn't mean I was brought up on that charge every month. The other interesting issue with the magistrate's decision was that we argued in court, it seemed like forever, on one issue as to whether my daughter's college education fund held at Smith Barney was actually a college education fund versus an education fund. It was the most ridiculous thing I've ever heard. It was actually always an education fund in case I wanted to send Phoebe, my daughter, to a like halfway brown school or something, that money would be there. I had it funded, and the argument, the decision came down that it was, the magistrate said that after hearing everything, even going against, I believe, what my broker said, that it was in fact a college education fund. Therefore, no funds could be used to pay for primary, call it primary, like K through 12, which put me in another financial bind because I didn't have any money to pay for parochial school, and they kept sending me bills saying I had to pay this, I had to pay this, I had to pay this. So I believe it was also retaliatory and punitive that the magistrate said, I am setting aside this fund for the child as a college education fund to be monitored by both husband and wife. And when the decree came down and we did our objections, that was not one of our objections. That's fine. It is what it is. It's a college education fund. I can live with that. But the judge, Forrest Burt, in his final divorce decree, after taking another 8 months of my life away, he overturned that decision of the magistrates. And it's mind-boggling to me that he said in his decision, oh, by the way, since the magistrate has decided that this so-called education fund is a marital asset to be split by the two parties, the husband and the wife, that's what I'm going to do. So he said, so she gets half of that money on her side, and Mr. Davis gets half of the money on his side. Well, he didn't, the only thing I can say is he didn't read the decision. The magistrate clearly said that it was an education fund to be used only for my daughter, and he makes this statement in his final decree that he's giving it away, and It took my ex-wife one week to go to Smith Barney, withdraw that entire amount of money, and buy a house. My daughter's college education fund is gone, and he didn't read the magistrate's decision properly.